I just have so many corporation note cards that do what I used to do for different subjects and just read them into YouTube. So starting just like in the middle, voting trusts, according to the Delaware General, I don't know, Corporation Law, Model Business Corporation Act, and California Corporation Code, giving the citations. Device by which shareholders separate the voting rights in and the legal title to their shares from the beneficial ownership of the shares while retaining right to distributions and appreciation, usually among greater than one shareholder. Type of pooling arrangement: A, B, and C. A, execute written agreement is a ceremonial requirement for stated period of usually or generally less than 10 years and documented by the corporation, and there's a transfer of legal title or stock certificate. Apparently, I read maybe all of the other note cards already up to this point, which is why I started where I started. Non-corporate entity formed under statute that combines corporate and partnership elements, mainly owner-member limited liability, for example, not liable for the debts. So the member owner manages and obligations, other liabilities, even by their actions and appearance. So this note card is clearly for the LLC, form of an entity. And when I say limited not liable for the debts, I'm talking about obligations and other liabilities, including contract and torts, and even by their actions, appearance. All right, so then I got a blank one on restricted stock on page 648. Anyone still has the book. I've stuffed in here a bunch of notes that I've recently taken. Invalid incorporation, colorable compliance with the incorporation statute, and exercise of corporate privileges. No liability if the corporation by estoppel. People treating the business as a valid corporation are stopped from denying the corporation's existence. So those are the different kinds of corporations that you get: de jure, de facto, and estoppel. What is it? I've got a whole list of things. Okay. So this right here is your 10B security laws. And I'm just listing out things that must be remembered about 10B under the security laws, which is security, misrepresentation, nexus, interstate commerce, materiality, scienter, primary participants, standing, causal relationship, transaction causation. Is less important in deciding how to act with total information available, and damages. There's going to be other definitions of that make more sense, but these are just like the baseline elements. Oh, in fact, let's see, what's this? This is the same. This is the 10B5. Fraudulent misstatement, cause a transaction, that wouldn't have occurred but for the misstatement, so was to create reliance or to meet the element of reliance, and loss causation, misrepresentation, cause economic loss to the plaintiff. Just so cute. This one looks like it says government, gov. Governance. Okay, so for governance, right up my alley, written policies, reviewed regularly, and employee training on, and this is what those should include the topics of business conduct, conflict of, not conflict, code of ethics, HIS, APC, antitrust, and insider trading. ARC, ABC, maybe like an anti-bribery, corruption. HIS, is that what that says? HIS. Code of ethics. Not sure what that means. Compliance program, compliance oversight to audit committee, whistleblower hotline, compliance access to general counsel, interrelated, CE, control effectiveness or control environment, risk assessment, control activities, information and communication monitoring. The next definition is implied partnership, limited partnership. So let's start with just the partnership. It's association of two or more to carry on as co-owners in a business for profit. It involves a fact-based analysis to find a partnership where no documented agreement is in writing. The agreement to share profits and losses are facts relevant to the analysis. Mutual right of control or management of business, community interest in the venture or common interest in the venture. Now, you have a limited partnership when the partnership is formed by two or more under the laws of the state and have greater than one general partner and greater than one limited partner. When they file a certificate with the Secretary of the State, this must contain the name of the limited partnership, the partnership names and addresses, planned dissolution date, and an agent for service of process. Next, I have loyalty, care, fair dealing, and good faith. These are clearly duties owed, probably by the directors. Actually, I have partners of a partnership. Now, for good faith, in contract standard of care, that the general partner reasonably believes that its action is in the best interest of and not inconsistent with the best interest of the partnership or business interest of the partnership. I'm not quite sure. So, fundamental changes include that require a shareholder vote include amendment of the certificate of incorporation or bylaws, a merger, sale of substantially all assets, election of directors, a dissolution, consider constituencies, which is your creditors, your customers, your employee, the community, your cultural interest, customer service, and great management deference is given to that analysis of the constituencies when I'm just saying, look at Unical, Paramount, and eBay. So the reason why we do this tends to be in an argument over tender offers like poison pills, merger activities. I don't have the definition of short swing. I might later, so we'll get to it. Duty of candor, completeness over adequacy. That's what I said there for duty of candor. Insider entrusted with fair dealing. I think it's fair dealing. No. I don't know what FD stands for, but fiduciary duty. Okay. So this is actually the definition of tipper liability. The insider is entrusted with fiduciary duty, that's trust, confidence, act in another's interest, confidence, custody, and the insider breached the fiduciary duty by disclosure of confidential information to a tippee in exchange for personal benefit. And the tippee must know and still use the information to trade or tip others. Now, next one is corporate opportunity doctrine. A director may not divert to himself a business opportunity within the corporation's line of business without first giving the opportunity to act. The remedy is the corporation may recover the director's profits or force the director to convey the opportunity to the corporation. Okay, directors and officers' duty to corporation is good faith. Does it say best interest of corporation? Shared by ordinary prudent person under like circumstances. I have lots listed here. The duty to monitor, the duty to inquire, the duty of prudence in decision making, the duty to employ process, which I think means governance, the duty of loyalty, sound business judgment, exercise, prevent waste, avoid self-dealing, corporate opportunity usurpation. Then I've numbered some things out. So those are all bullets. Here is to make decisions in a inaction not subject to business judgment rule unless deliberate. I actually don't know if that says inaction. Inform himself, good faith, and financial interest in subject of maybe decision. Now these all must be met 1 through 4 to equal reasonably the standard of review for reasonableness, I'm going to say. And then if all 4 are not met, again, making the decision informing themselves in order to make, prudent decisions, I'll just say. Good faith and financial interest in subject of decision. Okay, so this clearly is like some type of this note card stands for business judgment rule. So there's a lot going on here. There's distinctly 3 different parts of this. So the first part was really just listing out a litany of duties, like monitoring, inquiring, prudence in decision making, employ a process of governance, loyalty, avoid self-dealing and usurping opportunities, and preventing waste. Now, I think when a decision is like when you do have like transactions with insiders or something of that nature, what I think these 4 parts relate to that. And if all 4 of these parts are met, they're probably going to apply the business judgment rule, but if they're not met, they'll use another standard of review, like rationality. And I'm just going to move to the third part, which is generally protects directors. So this is more of the basic definition of the business judgment rule, is that it generally protects directors from personal liability, which I've described as improper benefit, tort, unlawful distributions. So it'll protect the directors from personal liability to the corporation and shareholders. If an act is in good faith, the person in some acts something ends in a manner reasonably in corporation's best interests. All right, so just gonna leave that where it is. Shareholder derivative suits, as opposed to a direct suit that goes to the shareholder to enforce the right of the shareholders. The derivative suit is to enforce a right belonging to the corporation, must have owned shares at the time of the wrong. Standing is required, contemporaneous ownership, must maintain ownership of shares throughout the suit, and demand the board of directors to bring a suit against the third party to vindicate the corporation's rights, and the proceeds will go to the corporation. So I'm shocked at how tired I am. Like a moment ago, I couldn't stop walking around. So equitable subordination. What is this? Piercing the corporate veil. So, ordinarily, a shareholder's right not liable for their corporation's debts when acting as a general partner in the limited partnership, and general partners owe a duty to the limited partners. So unless they, one, fail to maintain a corporate identity, like formalities of corporations, so they fail to maintain like a separate corporate identity, you start entering into the alter ego doctrine and conduct their own personal affairs through the corporation and intermingle assets between their personal assets and corporate assets. And there's insufficient capitalization of the corporation, which I have written here. The corporation must start with sufficient unencumbered capital to meet its prospective liabilities. Owners don't hold meetings, so that's more to the formalities are missing. Use of corporate assets for personal purposes, an entity formed to perpetuate fraud or to limit future liability, and thereby active shareholder is liable, generally liability only for tort obligations. So they're much more likely to find it in tort than contract. So that's piercing the corporate veil. Using meaningful cautionary statements, I believe, and that's called the B speaks doctrine, to avoid liability under what I was talking about, security laws, section 10b5. Here, the next one is appraisal remedy. The appraisal remedy, shareholders must make a written demand for appraisal either before a vote or within 120 days after, because of dissension was greater than impingement on business. And the statutory requirement is that greater than 1% shareholder of a 1 million probably company assets or something may receive a prejudgment no action letter. So I've written that, but really I've also decided to correct going in that direction and steer myself into an elemental analysis where there's 1, 2, and 3. 1, this requires notice of intent to exercise appraisal right before the vote is taken. Do not favor the fundamental change, like abstain from voting or voting for the fundamental change that wasn't properly noticed, for example, and demand the payment after the change is proved. I believe you demand that on the board before going out, before bringing an actual complaint. So, the next note card doesn't have a name. It says 14D Williams Act, disclosure of bidder regarding anticipated TO, tender offer. And then dissolution, voluntary if shares have not yet been issued or business has not yet commenced, a majority of the incorporators or initial directors may dissolve a corporation by delivering articles of dissolution to their share. After shares have been issued, corporation may dissolve the corporate act approved under the fundamental change doctrine. An administrative dissolution could happen for failure to pay fees or penalties, appointment of a registered agent, failure, and these are all failures, to file an annual report, or and the other form of dissolution is a judicial dissolution, can be caused by fraud. I wrote something here about articles of incorporation. So I don't know if they're related to one another, like fraudulent articles of incorporation, abuse of authority, deadlock, oppression, waste, insolvency. What more do I have? Okay. I'll start having some weird ones. Small scale merger. A merger that involves less than 20% of the survivor's shares is not such a major change as to require protections of shareholder vote. I gave this section 251 of the Delaware Code because other means of enlargement of I don't know what this says, do not require shareholder vote. Short form merger. So, aka parent sub mergers only require a board of director of the parent company to vote. Neither the parent or the sub shareholders vote is required. Doesn't offer an appraisal right. Often the sub board of directors doesn't vote. In the modern short form, often floor of 90% allows parent to eliminate lingering shareholders' interest by issuing money rather than stock to minority. Okay. So, so stock for stock. This is still another kind of a merger. Not necessarily involve assumption of liability. Vote of greater than 2 constituents shareholders may not trigger an appraisal. She was brighter over there. Stock for assets, because I just read stock for stock. Now I'm reading stock for assets. Involve sales tax, deeds, assignments, or transfers. Doesn't necessarily assume liability of the transfer's property. So let's distinguish between stock for stock and stock for assets. So in stock for stock, it does not necessarily involve an assumption of the liability, whereas in stock for assets, that's the same. It doesn't necessarily assume the liability of the transfer's property. And votes of greater than one constituent shareholders may not trigger an appraisal. In stock for assets, I don't really have anything like that. I just have it involves the sales tax, deeds, assignments of transferors. So I think you need to specifically say if you're assuming a liability. Now, let's look at proxy materials. The proxy statement and form of the proxy. The proxy statement. A written statement sent to shareholders as a means of proxy solicitation. Proxy solicitation. I'm glad it went in this order. The process by which shareholders are asked to give their proxies. Proxy, or form of proxy and proxy form. The written instrument in which such an authority is embodied. The term proxy is also sometimes used to mean a proxy holder, but for purposes of clarity, that usage will be avoided in the text. So I just crossed it out. Why am I reading this? Proxy holder. Person authorized to vote shares on a shareholder's behalf. All right, 14E 3A. What's all this mean? Because there's reading all over it. These are just notes. These are just notes from my job. Yeah, these are notes from one of my meetings. I had I networked with someone from work and took notes on this note card. Manipulation, not naming names, but they happen to be General Counsel of IT. Chief Operating Office. Manipulation. In securities market practices such as wash sales, matched orders, rigged prices, intended to mislead investors by artificially affecting market activity. So what's this defining? It's defining manipulation. Probably market manipulation. Again, wash sales, matched orders, rigged prices, intending to mislead investors by artificially affecting market activity in the securities market. Those practices are, what did I say? Manipulation. Now, loss causation, probably a part of the securities laws, includes proximate cause. The damages suffered by the plaintiff must in part be a foreseeable consequence of any misrepresentation or material omission. Misrepresentation touches upon the reasons for the investments, decline in value, not offset by intervening causes, not offset by lapse in time. Transaction causation, investors' reliance on the misrepresentation. Fraud on the market factors, percentage of shares traded weekly, analysts following, presence of market makers, not arbitrate. I'm going to say arbitrators, but I don't know. I can't read the end of this word. I know it has to do with arbitrage. Eligibility to take advantage of securities integrated disclosure procedures pursuant to Forms S3 for IPO, responsiveness of securities prices to new information, market cap of firm, bid-ask spread, percentage of shares owned by insiders, and institutional share ownership. So what the heck are those again? Fraud on market factors. Fraud on market. Those are the factors. What is it? The market price of shares traded on well-developed markets reflects all publicly available information, and hence any material misrepresentations gives rise to the presumption that all sales and purchases are reliant on all public misrepresentations, unless public information did not reflected in stock price or something otherwise severed sale purchase misrepresentation. Recklessness. Looks like it comes from a case called Sundstrand. Reckless conduct may be defined as highly unreasonable conduct involving not merely simple or even inexcusable neglect, but an extreme departure from the standards of ordinary care, which presents a danger of misleading the buyer or sellers that is either known to the defendant or is so obvious that the actor must have been aware of it. Sanders. Recklessness is not just lesser form of intent than merely a greater degree of ordinary negligence. We perceive it to be not just different in degree, but also in kind. All right, 10B elements for like the third time. Fraud or deceit in securities transaction, misrepresentation, omission, materiality, intent, interstate commerce, reliance, causation, and harm. What is instrumentality of interstate commerce? The Title 15 of the United States Code, Section 78J, requires in 10B or 10B5 action, use of any means or instrumentality of interstate commerce or of the mails or of any facility of any national securities exchange. Omission. State a material fact necessary in order to make the statement made in the light of the circumstances under which they were made, not misleading. And stock options, I don't have anything written there. So I've gotten through a lot. What's all this? Draconian defenses. I don't think I read this either. I'm going to read the rest of this. Illegal defenses to corporate takeover. Defensive charter amendments, crown jewel, white knight, Pac-Man, golden parachute, leverage buyout, dead hand provision of a poison pill, delayed redemption provision. So I know that was a lot in a short time. Those are illegal defenses to corporate takeover. Defensive charter amendments, crown jewel, white knight, Pac-Man, golden parachute, leverage buyout, dead hand provision of a poison pill, delayed redemption provision. Going dark, freeze out. Going private and taking number of shareholders below 300 to avoid SEC filing completely. Entity conversions. As an entity grows, it usually is both practical and necessary to reorganize itself into a different entity. Evolution. I don't know what this means. Core components is the something approval of the plan. Okay, the plan, approval of the plan, and filings with blank. Reverse stock split. Shareholder I don't know what that says. What's this supposed to say? It's supposed to be speaking to reverse stock split, and I just wrote shareholder emerges with fewer shares. Oh my God. Cash out merger. What's a cash out merger? New corporation which takes targets, probably assets, is just an issues debt, but cash does not issue cash. New corporation which takes targets assets issues debt, but doesn't. Debt or redeemable preferred mergers. New corporation, target merges into new corporation, no stock issued, rather debt, debentures, preferred stock convertible, interest created by debt, other term converted, and sale of assets, freeze out with the organization by S of the new corporation, T to merge with T issues debt. Target, that is. So dissolution, freeze out again. Dissolution, freeze out. S causes C to dissolve under a plan of dissolution, which provided that C's productive assets will be distributed to S or to an entity S controls, while money or notes will be distributed to C's minority shareholders. This is FYI illegal. Sale of assets freeze out. You write these like caveats in your articles of incorporation of like what you're going to do to prevent a corporate takeover in. Oh my gosh, Bubba just dive bombed. Are you okay? Yeah, you can't just put instructions. That's what the dead hand provisions are. You can't just put instructions in there to basically just like obliterate the company on the first act of indicative of a corporate takeover. That's what this would be. This would be like, oh my gosh, Elon Musk is coming for Twitter. We are now immediately going to make a bunch of unwise and stupid decisions, such as like giving all of our assets to somebody else or incurring a ton of debt. And those are like dead hand provisions. Now, what's disapproved but not illegal is the sale of assets freeze out. C's, controlling shareholders. S, organizes a new corporation. T, all of whose stocks owns. S, then causes company to sell its assets to T for money or notes. S owns C's business through T, while the equity interest of C's minority shareholders is C's business is involuntarily terminated. So like this is another like strategy, and I don't know if I'm explaining it quite right. This is called the sale of assets freeze out, whereas the last one was called the dissolution freeze out. I mean, I'm seeing this as like, okay, Elon Musk is coming after Twitter, so Twitter is going to just like be Pinterest. They're just going to be like, that would be the White Knight, I think, where they're like, anybody but this guy. And they're like, Pinterest, buy all of us, and we're just going to do business as you. Freeze out. Corporate transaction whose principal purpose is to reconstitute the corporation's ownership by eliminating the equity interest of minority shareholders. Forms of this are dissolution, sale of assets, debt or redeemable preferred mergers, cash out mergers, and reverse stock split. Share exchange. I'm just reading through these for like the first time in like a year. Shareholders of the acquired corporation vote on whether to exchange their shares for designated consideration from the acquiring corporation. Reverse triangular merger proceeds like a probably conventional triangular merger, except that instead of merging newly formed subsidiary of the newly formed subsidiary of survives. Valuable but transferable rights under contract but tax-free. So let's just read the forward triangular merger to try to understand what I just said under the reverse triangular merger. I mean, I remember the case that this came from, but it was like a Delaware, Pennsylvania case. Now, in the forward triangular merger, you've got this would be tax-free if substantially all of the property acquired by newly formed subsidiary to merger would have qualified as a reorganization, and 3 something about stock, I don't know, resale of newly formed corporation is used in transaction. De facto merger, probably should have started here. Not ordinarily taxed, assumes liability of target, triggers voting and appraisal rights, and shareholder of both constituents. So that would have made a lot more sense of all the other stuff. A consolidation is not defined. A statutory merger is also not defined. So those are the note cards in the book. Yeah, it is technically a book. All the stuff hanging out of the book that I read before, or just now. And now I've got some yellow note cards. including draconian defensive measures to avoid a hostile takeover. Draconian defensive measures are to prevent a hostile takeover are impermissible and can be either of the following and thus are not within the range of reasonableness per unical and require heightened scrutiny. Preclusive, deprives, and preclusive and coercive are the words here. So these two things are impermissible, both of them. Preclusive measures deprive the shareholder the right to receive all tender offer or precludes a bidder from seeking control by fundamentally restricting proxy contest or otherwise. And this is it creates a mathematical impossibility, realistically unattackable lockup. And for coercive, it's aimed at forcing upon the shareholders a management-sponsored alternative to a hostile takeover. Right. And no talk clause. So, this prohibits the board from discussing a merger of the corporation into a third party and provision. Basically, a tender offer's on the table. That means you really can't shop it if you have a no-talk clause in, like, the agreement that has been arranged between the target and the bidder. Green mail. Practice of buying out a takeover bidder stock at a premium that is not available to other shareholders in order to prevent the takeover. Dead hand provision. Rights plan cannot be redeemed except by the incumbent board of directors who adopted the plan or were their designated successors. That's actually a dead hand provision. It kind of I feel like it locks in the board of directors. It's like, oh, there's been a takeover, so you can't do anything now unless you have the old board vote on it. Right? Yeah. Fiduciary out clause. Where's he? What are you doing? Fiduciary out clause. This is a provision in a merger agreement that provides that another provision or covenant in the agreement which restricts in a certain way the discretion of the board of directors of a corporation to be acquired does not apply if the restriction would result in the breach of the board of directors' fiduciary duty to corporation and shareholders. So it would be wise to have something like this in an agreement. If they're trying to take it out, the question is is that a breach of a fiduciary duty to not have a fiduciary out clause? I know it sounds silly, but yeah, there's a case about it. Anyway, I feel like it was I just always think of it as in Delaware, chain, pharmacy chain. I just always think of Happy Harry's. Anyway, that case that came up. Now, poison pill, aka rights plan or shareholders' rights plan. A plan under which the board creates rights that are distributed or distributable to shareholders on the occurrence of an event to dilute the value, and it excludes the acquirer or the expected bidder. So this is, what I was defining before by memory as dead hand provisions, but it's not. It's called employees and pill, aka rights plan, aka shareholders rights plan. And then there's a flip-in feature and a flip-over feature. The flip-in feature of a rights plan is triggered when the acquirer crosses the specified ownership threshold, regardless of the acquirer's intentions with respect to their use of shares. It is normally triggered only by a corporate combination between the buyer and the target following the tender offer. Because I listened to any of that. It's okay. It's really not going to be on the bar. One thing that is going to be on the bar, and thus I'm reading it, is, again, 10b-5, which makes it illegal for any person to use any means or instrumentality of interstate commerce in connection with the purchase or sale of any security to employ a scheme to defraud, make an untrue statement, a material fact, or omit a material fact, or engage in a material or practice that operates as a fraud. Materiality is defined as a substantial likelihood that a reasonable investor would consider it important in making an investment decision. So here there's three parts of the definition. It's illegal for any person to use any means of instrumentality of interstate commerce in connection with the purchase or sale of a security to employ any scheme to defraud, make an untrue statement of material fact, or omit a material fact, or engage in any practice that operates as a fraud. That's the definition of what's illegal under Section 10b-5 of the securities rules. But I just defined materiality. Now I'll define intent. There's going to be a lot more breakdowns of this. For intent, the conduct must have been undertaken with an intent to deceive, manipulate, or defraud. That is scienter. Recklessness as to truth also appears to be sufficient culpability. The defendant need not have purchased or sold any securities. For example, a non-trading defendant can be held liable to a person who's purchased or sold securities on the market on the basis of a misleading press release. What else? A private plaintiff must prove reliance on the defendant's fraudulent statements or conduct. In cases of omission, reliance generally will be presumed. A private plaintiff must show the defendant's fraud caused the plaintiff damages. Damages are limited to the difference between the price paid or received and the average share price in the 90-day period after corrective information is disseminated. So those are the damages that the plaintiff has to show were caused by the defendant's fraud. 10b-5 also prohibits most instances of trading securities on the basis of inside information, that is, information not disclosed to the public that an investor would think is important when deciding whether or not to invest a security. A person violates Rule 10b-5 by trading if by trading he breaches a duty of trust and confidence owed to 1, the issuer, 2, shareholders of the issuer, or 3, in the case of misappropriators, another person who is the source of the material non-public information. 2, anyone who breaches a duty not to use inside information for personal benefit can be held liable under Rule 10b-5. 3, if an insider gives a tip of inside information to someone else who trades on the basis of the inside information, the tipper can be liable under Rule 10b-5 if the tip was made for an improper purpose, example, exchange for money, kickback, gift, reputational benefit. And 4, the tippee can be held liable only if the tipper breached a duty and the tippee knew that the tipper was breaching the duty. Section 16b requires the surrender to a corporation of any profit realized by a director, officer, or shareholder owning more than 10% of the class or the corporation stock from the purchase to sale or sale and purchase of any, which is a swing, of any equity during security within a 6-month period. So that's your short swing. And there's more to this on the next page. Page says, A, Sale or purchase test. Type of sale in which abuse of inside information is likely to occur. Transactions occurring before one becomes an officer or director are excluded, but transactions occurring within 6 months after ceasing to be an officer or director can be covered. The section applies to publicly held corporations, one with more than 10 million in assets and 2,000 or more shareholders or 500 shareholders who are not accredited investors, in any outstanding class or two whose shares are traded on a national exchange. Accredited investors include high income or net worth individuals and officers or directors of the issuer. Third, profit is determined by matching the highest sales price against the lowest purchase price for any 6-month period. May be either a gain or an avoided loss. I see you. Do I have nothing? Nothing, boy. Nothing, boy. I'll pour that. All right. Then Sarbanes-Oxley. Okay, here's your issue spotting checklist. Where you're gonna hit, what you're gonna hit on the corporations topic: organization, formation requirements, defective corporation, incorporation, de facto corporation, corporation by estoppel, promoters, liability for pre-incorporation agreements, directors and officers, how, when meetings are held and how actions are approved, how directors and officers are elected and removed, standards for directors' fiduciary duties, standard of care and business judgment rule, duty of loyalty, conflicting interests, transactions, corporate opportunity doctrine, officers' powers, application of agency law. As it pertains to shareholders, oh my gosh, can't believe we just did that head nod thing, babe. You're so good. Shareholders, relationship to management and liability, close corporations, duties of controlling shareholders, oppression of minority shareholders, piercing the corporate veil, how and when meetings are held, voting, particularity, proxies, irrevocability, and voting agreements, derivative suits, standing demand requirements, inspection rights, fundamental corporate changes, types of changes, including methods of dissolution, general procedure, and dissenting shareholders' appraisal remedy. So, there's my outline. I read this in this very same playlist. It looks like I thought I was going to write some more note cards. Oh my God, and I actually did, at least for some of them. Maybe like 3 more note cards. Closed corporation, nothing. Closed corporate member fiduciary duties. Generally, shareholders do not run corporations on the day-to-day business basis, except closely held corporations may dispense with the board of directors by a shareholder agreement and run corporation through different scheme. Jeez. Shareholder with controlling number of shares cannot use control to obtain a special advantage and at the expense of the minority shareholders. Duty of care, deal, nothing written there. Deal litigation. I just went through like a significant amount of things that are considered in deal litigation in like the yellow card pack, as well as all of those merger acquisition terminology. And duty of loyalty. For self-dealing, not voidable contract at instance of shareholder. And then I list out 3 things here. 1 is a fairness analysis, 2 is a number of disinterested directors approve, and 3 is a ratification as a complete defense. So, moving on. Corporate director duty, positive duty to seek out and remedy violations, positive duty to take measures to ensure they won't reoccur. Nothing for limited liability corporations and heightened pleadings, but heightened pleadings are for fraud. You can't just say fraud. You need to you can't just allege fraud or conclude that fraud occurred. You need to plead it with specificity. There's some essays we wrote. I wrote down partnership default rules, majority vote by a number of partners, ordinary matter, majority, extraordinary matters. For instance, to hire another partner, the partners must unanimously agree. Here are the hot topics, like issue spotting checklist on agency. This is the issue spotting checklist on partnerships. So there's like a dividing line here between agency and partnerships, but I'm gonna read about them anyway. Why? Because the bar is in 12 days. So major differences between, let's start with major differences between non-corporate business entities. For a general partnership, there's no required filing with the state or special name requirement. There's no limited liability partners. The partners all have management rights, and they equally allocate profits and losses. These are the default rules. And the rule on distribution is there's no provision allocating distributions. The limited partnership, on the other hand, as well as the limited liability partnership and the limited liability company, they all have state filing requirements. They all have special name requirements where they have to include like LP, LLP, or LLC, respectively. And liability of owners can be limited in all, but in limited liability partnership, you only to the extent that the partner is limited partner. And partners and members have management rights. This kind of depends on in all 3 of them. So for limited partnership, no. For limited partners, but they may, if otherwise provided by agreement. Limited liability partnership depends on whether the LLP is a general or limited partnership, and then a limited liability company, yes, unless operating agreement states otherwise, as it relates to the management rights. For allocation of profits and losses, for tax purposes, in a limited partnership, there's no provision allocating profits and losses. A limited liability partnership, it depends on the LLP, whether the LLP is a general or limited partnership. And for the limited liability company, there's no provision in the RULLCA according to value of contributions in most states. So next question is the rules on distributions. In a limited liability partnership, it's according to the value of the contributions, and it's equally in a limited liability company, according to RULCA, according to the value of contributions in most states. But in the limited liability partnership, it depends on whether the LLP is a general limited partnership again. So now I'm going to read the issue spotting checklist for partnerships. Just on the side. Formation, liability, property issues, dissolution, and disassociation, and other corporate unincorporated forms. So for formation, factors for deciding whether a partnership exists: management and operation, voting, remuneration, and distributions. So liabilities to third parties, when the Partners Act binds the partnership and actual first parent authority. Liability of the partners, who is liable for partnership obligations and to what extent. property issues, rules for determining partnership property, partners' ownership, interest in partnership, and transferability. Disassociation and dissolution, events of disassociation, events causing dissolution, and priority of distribution. Other unincorporated forms, their formation requirements, distinguishing the key characteristics, which I just did, of an LP, LLP, and LLC versus general partnership, and rights to participate in management and liability, and piercing the LLC veil. Moving on to agency, there's duties of the agent and principal, liabilities of the parties, liability for agents' contracts, and liability for agents' torts. For agents' duties, there's care, loyalty, and obedience. For the principal's remedy, the principal has remedies if the agent breaches, but the principal also has some duties, like to pay the agent. Liabilities of the parties, third party versus agent, impact of disclosed and unidentified, undisclosed principals. Liability for agents' contracts, actual authority, express or implied, is relevant. The apparent authority under this, there's 3 bullets: lingering apparent authority, secret limiting instructions, and when the agent exceeds authority, and ratification requirements and the effect. Liabilities for the agent's torts is determining employee versus independent contractor, and the scope of employment, whether it's a frolic or a detour. So all of the elements to those analysis need to be memorized. Now, is there any more that we can go over? Probably yes, but instead, keep on trying to put stuff away. This is another issue spotting outline. This is an essay. Hopefully these are all just essays. So we're going to go over those essays another time. Probably not in recording.